A Supreme Court fight is moving right now that could change where your carry permit works the second you step onto private property. Pause. And another update in Congress could flip your travel routine across state lines faster than most gun owners expect. Quick question. Before we continue, are you subscribed? Because what I am about to walk you through could save you from a terrible mistake at a gas station, a restaurant, or a traffic stop. Hit that button now, because laws like these do not wait for you to catch up. And if you carry every day, your routine is only as safe as your information. Let me break this down for you. This is not about wild rumors. This is about real court cases, real bills, and real state rules that are either already changing or could change very soon. And the reason this matters is simple. Most concealed carriers build habits. Same holster, same parking lot, same coffee shop, same drive home. But when the law changes, your habit can become your problem overnight. First update, watch the Supreme Court case about carrying on private property open to the public. This is the one that shocked me. The case is called Wolford versus Lopez. And the basic question is simple. Can a state make it a crime for a licensed concealed carrier to walk into a store, restaurant, or other business unless the owner gave clear permission first? Think about what that means in real life. Imagine you have a valid permit. You stop for gas. Then you run inside to grab water. In some states, that might feel normal. But under the kind of rule being challenged, silence does not mean yes. Silence means no. That is a huge change from what many people assume. Here is why this case matters so much. Hawaii has this kind of rule, and 4 other states have used similar ideas, including California, Maryland, New York, and New Jersey. So this is not some tiny island issue. This could shape how courts treat the default rule in many places. Do businesses have to post no guns to keep you out? Or do they get a legal default where you are out unless they say yes? Now, this is where it gets interesting. During the January 2026 argument, several justices pushed hard on the logic behind that rule. Some reports even described the debate using the nickname vampire rule, meaning you cannot come in unless you are invited. Funny name, serious issue. Because if the court blesses that idea, your everyday carry routine could change the moment you cross a private doorway. If the court rejects it, some states may have to rewrite big parts of their carry restrictions. Here's the part nobody is talking about enough. This is not just about walking into a gun store. It affects normal life. Grocery stores, strip malls, quick stops, family restaurants, hotels. Imagine trying to remember which private places need express permission, which need signs, and which are silent but still off limits. That is how honest people get trapped. Second update, keep your eye on federal concealed carry reciprocity. A lot of people hear that phrase and think one thing, great, my permit will work everywhere. Slow down, not so fast. There's a bill in Congress called the Constitutional Concealed Carry Reciprocity Act, also known as H.R. 38. It would create a federal framework for carrying concealed across state lines, if you are eligible in your home state. That sounds huge, because it is huge. If it ever becomes law, road trips could look very different. Crossing a state line might stop being the legal minefield it is today. But here is what most people get wrong. A bill is not a law, not yet. This one moved forward in the House process, but it has not finished the full trip. So if you travel with a handgun today, do not act like reciprocity already happened. It did not. And even if something like this passes later, you still cannot assume every state rule disappears. Sensitive places, local bans, transportation rules, and permit conditions can still create danger unless the final law and later court fights settle those questions clearly. In plain English, reciprocity could help you carry in more places across state lines. It does not mean you can stop reading signs, stop checking maps, or stop learning the rules. Here is a hypothetical example to explain this. Let us say you live in a gun-friendly state. You drive to visit family in a stricter state. You hear online that reciprocity is basically done. So you carry like normal. You stop at a place that serves alcohol. Then you take public transit. Then you walk through a park. If that state still treats those as banned places, you may have just stacked up serious problems without even knowing it. If you are finding this helpful, imagine what you will learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you do not miss it. I make these videos to save you time, stress, and mistakes. Third update, the biggest danger for most concealed carriers is not the permit itself. It is the map, the off-limits map, and that map keeps getting bigger in some states. Let me show you what I mean. In California, a 2025 state bulletin said more carry restrictions became enforceable after a Ninth Circuit ruling. That meant more places where permit holders could not carry, including bars and restaurants, playgrounds, parks, stadiums, libraries, amusement parks, museums, zoos, and casinos. Read that again. Not just schools and courthouses, parks, libraries, museums, places normal people go every week. But here's the crazy part. Some California rules are still tied up in court. So one set of locations may be active while another set is blocked. That creates the exact kind of confusion that gets people in trouble. You think, I checked this last year, but last year is not this year. Now look at New York. New York still requires a 16-hour classroom course and a 2-hour live fire course for concealed carry applicants. It also keeps a long list of sensitive places, including public transit, bars and restaurants, serving alcohol, many entertainment venues and places of worship, schools, protests, and even Times Square. That means your carry routine can change just based on what street you turned onto. And here is why I keep hammering this point. Most people think the biggest legal risk is getting denied a permit. But the truth is, once you have the permit, the next trap is location. Where can you carry? Where cannot you? What changed last month? What part is still blocked by a court? What part came back to life after an appeal? Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your situation. Let me give you a real-world example. Imagine you're visiting family in a state with strict sensitive place laws. You carry into a restaurant. You do nothing stupid. You're polite. You're sober. You're not threatening anyone. But the location itself is banned. That means your entire legal problem started before you sat down. That is why I say your carry routine matters more than your carry attitude. One wrong stop can undo 10 years of doing everything else right. But wait, there is something even more important. These states are not all moving in the same direction. One court may knock out one rule, while another court upholds 10 others. So if you listen to one short clip online and think, the courts killed these bans, you could be dangerously wrong. Hey, 73% of people watching right now are not subscribed. Do not be part of that group. Join the gun owners who want updates before headlines get twisted. Click subscribe, because I am tracking the cases, the bills, and the hidden details most channels skip. Fourth update. Your car is becoming one of the most important legal spaces in the carry world. And a lot of people still think, if it is in my car, I am fine. No, that assumption can wreck you. New Jersey is the perfect example. After Bruin, New Jersey passed a law with a pile of new carry restrictions. That included sensitive places, new rules, and a ban tied to carrying an operable firearm in a private vehicle. In 2025, the Third Circuit said New Jersey was likely not allowed to enforce that vehicle ban, at least at that stage. The same court also said the state likely could not use the private property default rule for places open to the public. But it upheld many other sensitive place restrictions. Why does that matter to you? Because it shows how messy this is. One part of the law falls, another part stays. So if your only rule is, I heard New Jersey lost, that is not enough. Lost what? Won what? Which section? Which stage? Which order? That is what you need to know. Picture a traffic stop. You're crossing a strict state. Your gun is on you or within reach. You think your permit covers the trip. But what does that state say about vehicles? About loaded guns in the car? About stopping on private property? About entering a prohibited place after parking? This is where good people freeze up, say too much, or rely on bad internet advice. Now, this is where it gets even more interesting. In Maryland, the Fourth Circuit ruled in early 2026 that the state could not ban carry on private property open to the public by default. But it upheld many other location bans, including government buildings, public transportation, school grounds, parks, museums, healthcare facilities, stadiums, casinos, and bars. That means a state can lose one huge rule and still keep a long list of others. So what is the lesson? Do not think in one big sentence like, this state is pro-gun or that state is anti-gun. Think in categories: private property, parks, transit, alcohol, cars, schools, events, protests. Because that is how the law is being fought right now, one category at a time. Fifth update, storage and reporting laws are creeping closer to your carry routine than many people realize. A lot of carriers only think about the gun while it is on their body. But the law often cares just as much about what happens when it comes off. Illinois is a strong example. New storage rules taking effect in 2026 require gun owners to keep firearms in a locked container if they know a minor, an at-risk person, or a prohibited person could access the gun. The law also shortened the time to report a lost or stolen firearm to 48 hours after discovery. And fines can get very serious. Here is why that matters, even if you do not live in Illinois. These laws show the direction some states are going. The legal question is no longer just, can you carry? It is also, what did you do with the firearm when you got home, entered a prohibited place, or left the vehicle? Here is a hypothetical example. You carry all day. You come home tired. You take the gun off and set it on a shelf. Maybe a teen is in the home. Maybe someone in crisis is in the home. In some places, that simple habit can now create legal exposure you never thought about before. Same thing with leaving a gun in a vehicle while you enter a place where carry is banned. If it is stolen and you miss the reporting deadline, that is a second problem. This information could literally expire after the next big court ruling or legislative session. Subscribe now, because the next video explains exactly what you need to do before these changes catch ordinary carriers off guard. So here's the bottom line. The next threat to your concealed carry routine is not always a total ban. Sometimes it is a new sensitive place, a new rule about private property, or a storage rule. And those small changes are exactly what trip up responsible people who follow last year law. If this video helped you protect your rights and your freedom, hit subscribe right now. Stay with this channel. I want you informed before the stop, the sign, and the mistake. And one last simple reminder, laws change fast. Court orders are not the same as legal advice, and your safest move is always to check current state law and talk to a qualified attorney.